Okay, welcome. Let's take a look at question 6 from July of 2010. It's a community property essay. Straight community property, again, very common issues. Community property essays tend to be relatively easy on the bar exam, just pretty much rule-based. Know the rules, apply principles of fairness, and get out of there clean as a whistle. Okay, number 1, let's go to the call of the question. In the event of dissolution, how should the court rule on Harry and Wanda's respective rights and liabilities with respect to, let's go to 1A, the condo in Hawaii. So we got condo in Hawaii. Depending on what island it is. Number 1B, the cabin in the mountains. Cabin in the California mountains. Sounds like that's beautiful. 1C, the bio stock. I'll just put stock for short, make it easy on you. And number 2, what property can Paul reach to satisfy his judgment against Wanda? So Paul versus W. Assets to reach. That looks like it's a debt. Okay. So let's take it from the top. And again, with community, it says answer according to California law. Very few subjects are California specific, wills and community property being the two main ones. There's also California evidence and California Civ Pro. It's not trust. Trust is not a California specific subject. Now notice that the fact pattern starts out in 2000, second paragraph in 2003, 2004, 2005, 2006, 2007. It's in chronological order. It's really easy to organize. I mean, you're just organized by the call of the question. Generally, they put that in order. Of course, they'll tie a couple of things together. You'll have to, use your mind to tie some things together. But for wills, community property, contracts, things are very easy to organize because the dates are just as such. Okay, let's take it from the top. 2000, Harry and Wanda, California residents, married. Perfect. You know the marriage starts in 2000. Harry was from a wealthy family and was the beneficiary of a large trust. Good for Harry. After their marriage, Harry received income from the trust on a monthly basis and deposited into a checking account in his name alone. Okay, so we have the money in the checking account, his name alone, which is fine. It's all separate property because he inherited it. Henry remained unemployed throughout the marriage. Hell, I'd be unemployed too if I was the beneficiary of a large trust. When he began working as a travel agent, she deposited her earnings into a savings account in her name alone. So that will actually go to whether or not there's going to be, we'll get into that in a second, whether or not there's going to be any type of reimbursement. So she's putting her earnings in a savings account. Now, the money in the savings account is technically community property, even though she puts it in her name alone. So you have to look at it like this. It doesn't actually, when title is in one spouse's name alone, the title does not determine the character of the property. Instead, the courts will look to the source of the funds that were used to acquire the property. So how did the savings account come about? Well, from the money that she earned. Earnings are community property. The fact that she put it in her name alone does not mean it's separate property. It's still community property. The title presumption does not matter. When title is in one spouse's name alone, you look at the source of the funds used. Okay. There's also a thing where if you keep your property in a separate account, who can't get at it? I forget how that works. Someone can't get at it if you keep it in a separate account. Oh, it's going to kill me now. Okay, I'm going to look that up a little bit later. Alrighty. Okay. Moving on. In 2003, Harry and Wanda purchased a vacation condo in Hawaii. They took title in both their names, so we have a joint title presumption. And that means when a couple takes property in a community in a joint form, which here we have joint tenants with right of survivorship, California infers an intent to change the property to community property. But Harry paid the entire purchase price from his checking account. Well, where does checking account come from? From his inheritance. So the checking account, which is in his name alone, is fine because it's still separate property. So he's now put separate property into a community property asset. So what happens there? He gets reimbursement. So it's the amount, so whatever it was worth in 2003, so 2003 fair market value, which is what he paid for it, will be reimbursed. So he'll get reimbursed the amount of money that he paid for it. Any appreciation is going to be community property because they put in joint title. They orally agreed that the condo belonged to Harry. Uh-oh. Oral agreements, transmutations. Well, it's after 1985, so before 1985, an oral agreement would be valid. Just really hard to prove. After 1985, you need an express declaration indicating that you know, as the adversely affected spouse, that there's a change in ownership and that there's a change in ownership and that you know that you're giving up all your rights to it. So he doesn't do that. And even the fact that they orally agreed to the condo, it's not, oral transmutations are invalid. We need an express declaration in writing. So what's going to happen here is, because he bought the condo with his own separate property from the inheritance that he put in his checking account, that he kept in his own name, it was not commingled with any of her funds, he used it to buy what he put a jointly titled property, so he's going to get reimbursed for the fair market value, that is what he paid for in 2003, and the transmutation is invalid because oral transmutations are not valid. We need an express written declaration when it comes to that. In 2004, Harry purchased a cabin in the California mountains to use when he went skiing. He paid the entire purchase price from his checking account. And he took the title in his name alone. So again, this is separate property, title in his name alone. It's fine because when title is in only one spouse's name, you're going to check the source. And where did the source come from? It came from his checking account. And where's the checking account? It was inheritance. It's pretty much the same issues repeating itself almost over here. So the cabin in the California mountain is Henry's only. I mean, it's pretty simple that it ends up being his separate property. That's the only issue there with the California mountains cabin. Why the examiners actually even chose to test you on something that simple, especially when they just did it over here, it's kind of beyond me. But sometimes they'll do that. So if it's easy, just go for it. In 2005, Wendy commenced a secret romance with Oscar. During the rendezvous, she negligently operated his car, causing personal injuries to Paul, another driver. So here we have a debt incurred during the marriage. So that means, you know, the community property is going to be liable. However, and of course, her separate property is going to be liable. The question is, which one's going to be taken first? Which one does Paul have to exhaust first? Well, is this for the benefit of the community? I can't see screwing another guy going to help the husband. So separate property is going to be liable first, and the community property is going to be liable secondarily. So Wendy's separate property, even though it was a debt incurred during the marriage, the order of satisfaction, because it was not for the benefit of the community, we have separate property liable first. That means her, she's the debtor spouse. She's the one who's going to be liable first, community property second. 2006, Wanda received an email advertisement inviting her to invest in stock in a bioenergy company. She discussed it with Harry, thought it was too risky. Nevertheless, she purchased the shares of stock using $20,000 from her savings account to make the purchase. She put the name in her name alone. Again, title in her name alone, check the source. Where's the source? The source was the savings account. And what's the savings account? It's from earnings. And what are earnings? Community property. So the stock is community property. That's how that's going to play out. And another thing, too, is we have a fiduciary relationship between couples, between married couples. And she has to do good faith and fair dealings. He said to her, hey, this is too risky. Nevertheless, she bought it. So I wouldn't necessarily think this is grossly negligent conduct or reckless conduct. It's pretty, I mean, I can't even really say it's stupid. I mean, it's just a little careless. She didn't know what she was doing. She blew $20,000. So that's the way it is. I mean, he could kind of make a claim saying she breached her fiduciary duty of good faith and fair dealing because they discussed it and they said no. But hey, he doesn't have the final say in things. I mean, the man doesn't have the final say. This is way past 1975. So therefore, it is what it is. The bioengineering stock, which is probably, what's it worth? Almost nothing. I don't know what it's worth now. Stock has lost almost all its value. Whatever value it does have, it is community property. Continuing on. 2007, they separated. Shortly thereafter, as a result of the accident, Paul obtained a judgment against Wanda. Again, it doesn't matter when the judgment was obtained. It's when the cause of action accrued. And the cause of action accrued, when did the accident occurred? During the marriage. So even though it's, and this is the way the fact pattern, the examiners always do it, the settlement always comes after the fact, but don't worry about it. It's when the cause of action accrues, and I guarantee you, on your bar exam, it'll accrue during the marriage, because it's the way they want to test it. Henry and Wanda are now considering dissolving their marriage. The condo and the cabin have increased in value. Well, the cabin, it's all separate property, so let it go. The increase in value is community property. So the increase is community property. But he's going to get reimbursed for what he paid for in 2003. Obviously, it increased over 4 years. I shouldn't say obviously, because the market actually took a dive pretty quickly after that. But any increase is community property, but the purchase price was separate property. So the event of dissolution, how should the court rule on their respective rights? Again, the condo was separate property, was from the money that he inherited, put in his checking account, didn't commingle it, entirely is separate property. But then when he put it in joint title, it's community property presumption, which is not going to be overcome because there's no writing indicating anything different. So, but his separate property contribution is entitled to reimbursement, and that's going to be the fair market value or what he paid for it. So they did change the title to community property, so now it's a community property asset. But even though they orally agreed that would be his, there was no express declaration in writing showing that there was a change of ownership, that Wanda knew she was giving up her rights, like, hey, I have no rights in this. She only said it orally, which is not valid. So it is a community property. The increase is community property. The value of it in 2003 is separate property, and that's what's going to get reimbursed. The California Mountains, again, title in his name alone, but it was from the source, was from the inheritance, which again was from his checking account. It's his sole and separate property. The bioengineering stock, she bought it from her savings. She used her savings account, which contained her earnings, which are community property. So even though she put it in her name alone, I think she did or not, she didn't. Nevertheless, it's still community property. There's also a fiduciary matter here because he's going to argue that she was reckless in doing so or grossly negligent, but I don't think this rises to the level of breaching a fiduciary duty, although there is a duty between spouses for good faith and fair dealing. And finally, what can Paul reach to satisfy his judgment? Well, this was a debt incurred during the marriage. The fact that it was settled after the fact doesn't matter. The cause of action accrued during the marriage, so it's a debt during the marriage, which means the debtor's separate property, her separate property, and all the community property is liable. In order to determine the order of satisfaction, is it for the benefit of the community? Clearly it's not for the benefit of the community. Then her separate property is liable primarily, community property is liable secondarily. And that is all we got for this essay. That's a wrap on question 6 from July of 2010. Feel free to read the model answer, look at the critical breakdown, really understand this. Common issues that are always tested on community property. You definitely need to know it. Thanks a lot.